Warrantless stop permitted when police reasonably believe emergency aid is needed to protect life, prevent serious injury. State of Ohio versus Richard E. Dunn, case number 2011-0213. Second District Court of Appeals, Montgomery County.
Well, here in this situation, there was no testimony from the dispatcher about the reliability of this tip.
That's right.
And I think that's what the second district focused on, is that all you have is the officer who is the recipient of the information, and he's given, the name of Big Sandy or whatever on the truck and the description of the truck, and he's familiar with this truck. So that's not at issue. It's the fact that the man who's driving this truck is armed and is going to commit suicide. There's the pack of additional information that there was no testimony at the trial court to establish that his response was reasonable based on the dispatcher's receipt of information.
But there was some additional information attached to that, which is that truck was linked to the location where the report said that the suicide would happen, and he saw the truck within 90 seconds of the report on the road within 2 miles of the address where this was supposed to happen. So in a way, it wasn't a bare tip. If a stop is based on a dispatch which was based on nothing but an anonymous tip, there's got to be some reason to think that that tip is reliable or the caller credible. What I'm saying is that analysis makes sense in the context of a Terry stop where you're solving
But
crime.
that's a criminal activity.
Right.
But you're saying that standard should not apply when an officer is on an emergency response because of the different concerns that are present.
I'm saying the absence of that is not determinative. It doesn't mean that the officer necessarily acted unreasonably. If the officer knows that, that's great. It fits in. If there is reason to think that tip is reliable, it's not that it's not relevant at all. It's just that it's not determinative. It doesn't torpedo the rest of the grounds that the officer searched. The question is, under the totality of the circumstances, given what the officer knew, did he have grounds to believe that there was an emergency that required immediate action?
Is it your position that because there was no identified caller, that the police officer should not have responded to this call?
That is one of the factors that should be considered here.
And isn't it ironic that because he did, your client may be alive today to contest the violation that you're claiming?
That is 20/20 hindsight, perhaps, but I understand the point.
You have a guy who, you get a tip and they say, this is the car he's driving, he's going to go commit suicide, and your position is that does not give the police enough to go on. And if the police had not acted on that tip, wouldn't you be standing here suing the state for a reckless, ignoring an emergency situation and causing somebody's death?
I wouldn't be, but I could see where someone might make that argument.
So they're damned if they do and damned if they don't.
Well, maybe a better fashioning would be that under the circumstances, as was articulated by the appellant, that, these stops can be made, and this is the parameters by which a police officer can respond to an emergency, and the specificity of the tip or the examination of whether or not that tip meets all the indicia of reliability, is case by case, but maybe that stop cannot produce an arrest.
On March 15, 2012, the Supreme Court of Ohio held that when police officers reasonably believe there is an immediate need for their assistance to protect life or prevent serious injury, they may make a warrantless stop of a person to render aid without violating the subject's Fourth Amendment right against unreasonable search and seizure. The court's 6-1 decision, authored by Justice Evelyn Lundberg Stratton, reversed the ruling by the Second District Court of Appeals.